Hello, my name's Olorotimi Osha. On July the 16th, 2026, Congressman Morgan Griffith from Virginia introduced a bill uh, that is End Birthright Citizenship for US Territories Act uh, with the intention of ending birthright citizenship in U.S. territories, right? U.S.'s unincorporated territories. Uh, Unincorporated territories include Puerto Rico, Guam, uh, the Virgin Islands, and the Commonwealth of the Northern Mariana Islands. So those are some of the unincorporated territories. This bill didn't include the proposal didn't include Samoa Islands, right? Because apparently on the Samoa Islands, they already do not have automatic birthright citizenship. So people born on the island of Samoa are U.S. nationals, not U.S. citizens. So there's no birthright citizenship there. So of course, this came in the wake of the June 30th, 2026 Trump versus Barbara case, in which this U.S. Supreme Court upheld birthright citizenship as being guaranteed in the U.S. Constitution and struck President Trump's executive order attempting to end birthright citizenship. Now, of course, critics, those who are against what they call birth tourism and they want to end birthright citizenship, right? They insist that that decision by the U.S. Supreme Court only affected the states, the 50 states, right? That's with respect to the 14th Amendment. Of course, the 14th Amendment says all persons born or naturalized in the United States, uh, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, right? So, uh, let me take that again. All persons born or naturalized in the United States and subject to the jurisdiction thereof and the state wherein they reside are citizens of the United States. So uh, the critics claim that that 14th Amendment applies to only the 50 states and it doesn't apply to unincorporated territories like those I just listed, that Guam, Puerto Rico, the U.S. Virgin Islands, and Northern Mariana Islands. So, although currently people born in those territories, which are not states, they're unincorporated territories. The Puerto Rico is U.S. soil, right? The Virgin Islands are considered U.S. soil, those unincorporated territories, right? They're not states, they've not been annexed, absorbed as states in the United States, right? Um, so critics say that although they have birthright citizenship currently, but they have birthright citizenship not by virtue of the U.S. Constitution, but by virtue of a federal law, by virtue of statute, right? Their birthright citizenship comes from a statute which Congress created, and Congress therefore has unilateral power to end, right, to revoke that, to change that statute, to end birthright citizenship by creating a new law, right, which would state that children born to non-citizens or non-permanent residents are not citizens, right? And so that's the purpose of this bill. The bill introduced by Congressman Morgan Griffith from Virginia. Again, the name of the bill is End Birthright Citizenship for U.S. Territories Act. Um, However, those who are in support of birthright citizenship and say that this is guaranteed in the U.S. Constitution, right, as the Supreme Court justices upheld, right, state that the territories are part of U.S. soil, right, that the 14th Amendment applies to people born on U.S. soil, right, and that the territories are part of U.S. soil. So in any event, Congress has already submitted the legislation, right? But again, this legislation, the law would, if it passes, right, it would only apply to the territories, right? The territories are Puerto Rico, Guam, U.S. Virgin Islands, and Northern Mariana Islands, right? So try and memorize them. So America has more than just the 50 states. Those territories could decide to go on to become states, right? And the U.S. Constitution will apply to them as well. But right now, although they do have birthright citizenship, it's not by virtue of the U.S. Constitution. But in any event, if that law passes, right, it will be subject to what's called judicial review. Judicial review is the power of the United States Supreme Court to review laws passed by Congress or an order, executive order passed by the executive, right? But that's including the president, and decide if it's constitutional or not. And if they decide it's unconstitutional, they can strike it down, just like they did in the case of Trump versus Barbara, right? So that was a judicial review, and they struck down the executive order of President Donald Trump in Trump versus Barbara, saying it was unconstitutional. So, and people think this is like testing the waters for Congress to eventually create a law that will end birthright citizenship, right? With respect to subject to the jurisdiction, right? So scholars think subject to the jurisdiction was the sticking point, right? It's a sticking point that in the 14th Amendment, that who is subject to the jurisdiction, right, thereof. Now, it's not as easy as that, Congress, because, yes, Justice Brett Kavanaugh did suggest that Congress can create a law, right, and then define who's subject to the jurisdiction thereof, and they could exempt people who are not, parents who are not citizens and who are not permanent residents, right? That if they're not permanent residents and they're not citizens, then they're not subject to the jurisdiction thereof, right? So they could do that, just redefine what that is. Yeah, but it's not as easy as that, right? It's not as easy as that because, again, the Supreme Court would have the power to review it again, right? So if Congress passes that law, it wouldn't be, it's not going to be self-executing. It wouldn't just be automatic. The Supreme Court has the power of judicial review, so they can look at that law and decide again. And in all likelihood, considering the Supreme Court already feels this way, the current Supreme Court feels that birthright citizenship is guaranteed in the Constitution, and originalists like Justice Amy Coney Barrett would go back and, as an originalist thinker, I probably should do a video and explain what an originalist is. So as an originalist and textualist, right, her orientation, her philosophy is that she looks at cases and the Constitution, what's in the Constitution, based on what the drafters, the framers, and the public thought at the time, right? That's what she's going to be looking at. Clearly, in 1868, when the 14th Amendment was created, Americans thought it was diplomats who were not subject to the jurisdiction thereof. Diplomats and foreign occupiers, right? An occupying force. Those were the parties not subject to the jurisdiction thereof. And so she wouldn't change her mind, considering if Congress were to create a new law and state, well, that people who don't have permanent residency or international students and undocumented immigrants are not subject to the jurisdiction thereof, right? she wouldn't change her mind. She'd go back as an originalist and say, well, back then it was clear who subject to the jurisdiction thereof meant. It meant diplomats, right, were exempt. Diplomats were not subject to the jurisdiction thereof. So it wouldn't cause her to change her mind. Now, in terms of Justice Roberts is also, you can see he's firm on this as well. He's firm with regard to birthright citizenship. And, he's an institutionalist, while he hasn't identified himself as an originalist, but he's an institutionalist. It's something that's been done for the past, over 100 years, right? Over 100 years, over 150 years, we've understood it that those not subject to the jurisdiction thereof were diplomats, right? And so he would stick with, his principles that, well, birthright citizenship is protected and guaranteed in the US Constitution. You can see from his opinion that he was resolved on this, that birthright citizenship is protected in the US Constitution. So it wouldn't matter that Congress creates a new law redefining who is subject to the jurisdiction and exclude undocumented immigrants or temporary guests, right? So it wouldn't matter to those two. And we already know how the progressives, that's Justice Ketanji Brown Jackson, Justice Elena Kagan, and Justice Sotomayor feel about it. And so I think with respect to the composition of this court, they would strike down any law redefining subject to the jurisdiction with respect to the 50 states. However, it is likely that there wouldn't be a strong judicial challenge with respect to ending birthright citizenship within the territories, right? Within the territories, because the Samoan Islands, right, we already have a precedent, right? We already have a working instance with the Samoan Islands. They don't have birthright citizenship, and the Samoan Islands is also an unincorporated territory, and they don't have birthright citizenship. So they're just U.S. nationals, right, at birth. And so we might find a case where Puerto Rico, Guam, the Virgin Islands, and the Commonwealth of the Northern Mariana Islands would end birthright citizenship, right, in those territories. In any event, I hope this helps. My name is Olurotimi Osha. I will talk more on judicial review, and I'll keep you posted. Thank you.